Hi everyone. The purpose of this video is to briefly look at the face mask cases that have come before the WRC to date and the decisions they have reached in these cases. I will also provide some tips on arguments that can be used to secure a successful WRC decision using the decisions that have been published to date. The first point to note is that to date there have only been approximately 10 judgments published by the WRC involving a person being refused services because they were unable to wear a face covering. In light of the length of time, it would appear that these cases are taking to be heard. I expect that a great number of face mask cases will be heard in the next few months, so I hope the timing of this video is helpful. We will now take a brief look at the cases that have been determined by the WRC to date. The first complaint is Geraldine Fitzmaurice versus Dublin Bus. This complaint was submitted by Geraldine Fitzmaurice arising from an incident that occurred on Dublin Bus on the 3rd of September 2020. The facts of this case are as follows. The complainant boarded Dublin Bus without a mask. The driver alerted the Gardaí, who happened to be nearby. The Gardaí asked the complainant to leave the bus, which she did. The complainant later filed a complaint with Dublin Bus and sent them a copy of her medical exemption, which had not been shown to the bus driver or the Gardaí previously. As you will probably be aware, there are strict timelines inside which you are required to initiate a claim for discrimination through the WRC, whereby the first notice must be served on the respondent within 2 months of the incident occurring. The WRC has a discretion to extend this period to 4 months in exceptional circumstances and may even dispense with the time period entirely where they deem it fair and reasonable to do so. Before determining whether the complainant had suffered discrimination by Dublin Bus, the adjudicator confirmed that she could not deal with the substance of this complaint as the complaint had been sent to Dublin Bus 2.5 months late and to the WRC 1 day late. The takeaways from this case are as follows. 1. If you have failed to initiate your complaint within 2 months of the incident occurring, the WRC has the ability to extend this period to 4 months if you can meet the test of explain and excuse. It should also be noted that the WRC has the ability to dispense entirely with the notice period where they deem it fair and reasonable to do so. So if you have filed your complaint late, make sure you have a good explanation for the delay and proof if possible. The second complaint is Miroslaw Klos versus Unilex Limited trading as Abracadabra Carlo. This complaint was submitted by Miroslaw Klos arising from an incident that occurred on the 10th of December 2020 in an Abracadabra takeaway in Carlo. The facts of this case are as follows. The complainant stated that he was refused services in Abracadabra because he was unable to wear a face covering, and irrespective of the fact that he provided a medical exemption to the person serving him that day. The respondent stated that they did not refuse to serve the complainant and actually took his order, but that the complainant's order was cancelled and refunded because he started recording the interaction and refused to delete the recording when asked to do so. Before getting into the substance of this case, the respondent asked that the adjudicator consider whether the claimant had met the notice requirements under the Equal Status Acts, namely that the complaint be served on the respondent within 2 months of the incident occurring. In this case, the complainant sent the ES1 form to the respondent by registered post within 2 months of the incident occurring. However, on post returned the ES1 form without any explanation as to why it had not been delivered. The respondent argued that the claim was not in the jurisdiction of the WRC as it was out of time and asked that the case be dismissed. The WRC agreed that the claimant did try to serve the complaint on the respondent, but also stated that once the claim was returned by on post, the claimant was obliged to make further efforts to serve the complaint. The WRC determined that they could not investigate the claim as it was outside of their jurisdiction because the notice requirements had not been adhered to. The takeaways from this case are as follows. 1. If on post failed to deliver your complaint, there is an onus on you to try and serve the complaint again. In this regard, I would suggest that you serve the complaint by registered post, ordinary post and email if possible, and note on the ES1 form that it has been served using all 3 methods of service. 2. It is open to an adjudicator to dispense with the time period for notifications where they feel it is fair and reasonable to do so, which one might have expected in the present case, given that the claimant did make a genuine effort to serve the complaint on the respondent. The point to note here is that it is highly unlikely that any adjudicator is going to extend the time period for service of face mask complaints, so make sure your complaint is served within the 2 months of the incident. 3. The final point to note is that this is the second of 2 cases where a complainant had a valid medical exemption from the requirement to wear a face covering that was thrown out by an adjudicator before even considering whether any discrimination took place. So be aware that any and all tactics will be used not to decide on the substance of these cases, particularly if you have a written medical exemption. The third complaint is James Oliver Tatten versus the Gresham Hotel. This complaint was submitted by James Oliver Tatten, arising from an incident that occurred on the 16th of December 2020 in the Gresham Hotel, Dublin. The facts of this case are as follows. The complainant stated that he was attending the hotel on the day in question for a meeting, noting that he had been going to the hotel for 40 years. Upon entering the hotel, the claimant was approached by the hotel porter, who asked him to put on a mask. The claimant told the porter that he was exempt and stated that he tried to show his exemption letter to the porter, but he refused to look at it. The hotel stated that it reviewed its CCTV and it didn't show the complainant producing any documentation, but the CCTV was not available at the hearing as the hotel had erased it. The porter has since left the employment of the hotel, meaning that he could not be called as a witness. The claimant brought his exemption letter to the hearing to disclose to the WRC. The hotel stated that its policy was to offer a face shield to those unable to wear a face covering. The claimant said this offer was never made to him. The claimant had also asked the porter 3 times if he was being put out of the hotel. The claimant stated that he left the hotel embarrassed. The adjudicator confirmed that there was a conflict between the submissions, but accepted the claimant's evidence, probably because his medical exemption predated the incident and CCTV was not available when it should have been preserved by the hotel. In this case, the claimant was successful, but he was only awarded €500, which seems like an outrageously low sum given that the Gresham Hotel was found guilty of discriminating against a person because they had a disability. The takeaways from this case are as follows. 1. Even if an adjudicator finds that you have been discriminated against because you were unable to wear a face covering, and even if the respondent destroys evidence in a clear attempt to obstruct justice, you are likely to only be awarded a small sum of money in compensation. 2. In this case, the adjudicator stated that he accepted the claimant's evidence that he was not given the option of wearing a face shield and felt that he had no option but to leave the hotel. In light of this statement, I think it is likely that the adjudicator would have considered a face shield to be a reasonable accommodation if it had been offered to the claimant. And if the claimant had been offered and refused a face shield, the claimant may not have been successful before the WRC. The point to note here is that if you are unable to wear both a face shield and a face covering, try and ensure that your exemption makes reference to both, and if it does not, make sure you have a good explanation for why you cannot wear either. The fourth complaint is Anthony Lyttle versus Buywise Discount Stores, Costcutter, North Strand. This complaint was submitted by Anthony Lyttle, arising from an incident that occurred on the 5th of January 2021 at Costcutters, North Strand, Dublin. The facts of this case are as follows. On the day in question, the claimant attended at Costcutters to purchase milk and was asked by a staff member to put on a mask, to which the claimant responded that he was exempt. The claimant stated that he would speak to the manager outside rather than discuss his disability in the store. When the manager came outside, he told the claimant he would need to put on a mask or show him a medical exemption. The claimant responded by advising the manager that he had a reasonable excuse and was not required to produce any evidence. The respondent advised the claimant that the shop policy was that everyone wear a mask or provide an exemption letter. The claimant left the shop. At the hearing, the claimant advised the adjudicator that he suffered from claustrophobia and this prevented him being able to wear a face mask. However, as the claimant had not been to a doctor in 20 years regarding this condition, he did not have any medical proof of this fact. In her ruling, the adjudicator confirmed that, in order to establish that a case of discriminatory treatment has taken place, the adjudicator must be satisfied that the claimant suffers from a disability and that the respondent was aware that the claimant suffered from a disability. The adjudicator confirmed that it was only after a prima facie case of discrimination had been established by the claimant does the burden shift to the respondent to rebut the presumption of discrimination. In this case, the adjudicator determined that the claimant did not provide any evidence to prove he had a disability or that he was treated less favourably because of his disability. Therefore, the claimant had not established a prima facie case of discrimination on the grounds of disability, so it was not necessary for the respondent to rebut the presumption of discrimination. The takeaways from this case are as follows. 1. While you do not have to provide medical evidence of your disability to the shop in question, it is quite likely that if you fail to provide medical evidence at the WRC hearing, the adjudicator will not accept that you have a disability, and if you do not pass this first hurdle, the substance of your case will not be decided upon. 2. While you do not have to provide medical evidence of your disability to the shop in question, given that the second part of this test requires that the shop is aware you have a disability before they can be found guilty of treating you less favourably because of your disability, it follows that your case is unlikely to be successful if you refuse to disclose to the shop the nature of your disability. 3. Be aware that the adjudicator hearing your case will have their own views on COVID-19, and these views could easily prejudice their decision making. In the present case, the language used by the adjudicator is most concerning and leads me to believe that they may have had a bias against the complainant from the commencement of proceedings. In particular, the use of the word refusal in background as opposed to inability is concerning. In this case, the adjudicator is saying that the complainant refused to wear a face covering as opposed to was unable to wear a face covering. The language in this background information section should be neutral, but the word refusal is far from neutral, and the distinction between a refusal and an inability in the context of these cases is of paramount importance. The fifth complaint is Bernard Carberry versus T. O'Higgins and Company Limited. This complaint was submitted by Bernard Carberry arising from an incident that occurred on the 12th of January 2021 at T. O'Higgins Home Value Hardware Store in Galway. The facts of this case are as follows. On the day in question, the claimant went to Home Value Hardware Store in Galway to buy parts to fix a toilet in his family home. Upon entering the store, he was asked to put on a face mask by a person working in the store, to which the claimant responded that he was exempt on medical grounds. At this stage, the respondent asked for proof of the medical exemption, to which the claimant advised he was not required by law to provide any such proof. As the conversation escalated, the claimant began recording the interaction. The respondent asked the complainant to stop recording and he refused, at which point the complainant was asked to leave the store. It should be noted at this stage that the respondent confirmed that other customers became involved in the conversation and started demanding that the claimant put on a face mask. I want to stop here for a moment to express my disgust that anyone would deem it appropriate to interfere in a private conversation where private medical information is being discussed to demand anything. The fact that this was allowed to happen by the store is a disgrace and shows the utter contempt that this store had for people who were unable to wear a face covering because of a disability. Back to the case. The respondent stated that it was incumbent upon the complainant to prove that he had a disability to come within the scope of the Equal Status Acts, and because the complainant did not explain to the respondent what condition rendered him medically unable to wear a face covering, the complainant could not succeed in his case. The adjudicator stated that it is well established that the first test that must be met is that the complainant must be able to demonstrate that they have a disability, and if required to do so, they must be able to provide evidence to support that claim. The adjudicator found that in circumstances where the complainant was either unable or unwilling to support his claim of having a disability by producing medical evidence, there was no point continuing with the hearing, as there was no possibility his claim for discrimination could succeed without passing this first test. The takeaways from this case are as follows. 1. The adjudicator highlighted the fact that the complainant was well versed in the law around face coverings and noted that he had advanced an argument that if the respondent was claiming that he must wear a face mask in order to protect his staff, then the onus must surely be on the respondent to prove the effectiveness of face masks. In response to this, the adjudicator stated that the respondent is certainly not required to justify public health guidelines per se, specifically the requirement to wear masks. He has as much say or control over such guidelines as the complainant, which I suggest is very little, given these instruments of public health policy were decided by government advisors and ministers, as is well known. The adjudicator was either incompetent in failing to understand the argument being advanced by the complainant or deliberately did not want to address the issue. The complainant did not suggest that the respondent had any say over whether a law around face masks was in place, noting that the adjudicator incompetently referred to these laws as guidelines. The complainant suggested that if, in its defence, the respondent wished to advance an argument that harm might be caused to his staff if the complainant did not wear a face mask, then the onus must surely be on the respondent to prove the effectiveness of face masks. These are two completely separate issues, which I have no doubt were conflated by the adjudicator deliberately. 2. The second point to note is, in this decision, and this is even more outrageous, the adjudicator stated that distress and not being able to wear a mask could not be taken at face value to meet the terms of any of the 5 definitions of disability set out in the legislation, or indeed if such a reaction is a medical condition. Such a reaction does not amount to an obvious and readily acceptable disability. In this regard, I would suggest that the adjudicator reconsider the definition for disability, and in particular Section E, which provides a condition, disease or illness which affects a person's thought processes, perceptions of reality, emotions or judgments, or which results in disturbed behaviour. In my view, the majority of persons claiming an exemption from the requirement to wear a face covering on the basis of a disability would do so on the basis of this Section E. But again, it was very convenient to be able to disregard severe distress as a disability for the purposes of finding against the complainant in this case. The 6th complaint is Amanda Dobson versus Mullingar Specsavers Limited. This complaint was submitted by Amanda Dobson arising from an incident that occurred on the 20th of January 2021 at Specsavers in Mullingar. The facts of this case are as follows. The complainant secured a face mask exemption on the 9th of September 2020. On the 20th of January 2021, the complainant went to Specsavers to have her eyes tested to allow her to renew her driving licence. Upon entering the shop, she was asked where her mask was, to which the complainant responded that she did not require a mask, that she was there that day to have her eyes tested in order to renew her driving licence. The conversation became heated and the complainant decided to record the interaction as evidence of the way she was being treated. The complainant was then asked to leave the shop. At this point, the staff in Specsavers decided to contact the Gardaí, who proceeded to stop the complainant as she was travelling home to ask her why she had travelled into town that day. I want to stop here again for a moment to express my contempt for the Gardaí in this case. I would question how many people go to an optician to have their eyes tested when they are not required to do so. If the claimant was attending the optician, this was clearly an essential journey. I can only surmise that the purpose of stopping her that day was to harass and intimidate her. This is deplorable. In its submission to the WRC, the respondent stated that the complainant was not refused service because she was unable to wear a mask, but because she had started recording the interaction and threatened to post it on social media. The respondent also stated that the conduct of the claimant felt threatening. The adjudicator held that the complainant was not victimised and that the claimant did not establish a prima facie case that she was discriminated against because of a disability. The adjudicator accepted that the operative cause of the claimant being refused service related to the manager's concerns that her right to privacy would be violated by a video being posted on social media, as opposed to the claimant being refused service because she was unable to wear a face covering. The takeaways from this case are as follows. 1. Yet again, we have another person who has a written medical exemption from a doctor, and we have the WRC sidestepping the issue of discrimination by accepting that the cause of refusal of service was recording of the incident as opposed to the claimant's inability to wear a face covering. So be warned that any and all tactics will be used so that the substance of these cases are not given consideration. 2. If you intend to record an interaction, you should inform the person you are recording while the recording is taking place that you are recording the interaction to produce as evidence at the WRC or court and do not intend to share it with any other third party unconnected to such hearing. On a personal note, I want to say that I think it is outrageous that the manager of the shop can claim a right to privacy as a reason to refuse service, whereas the claimant's right to privacy in having to produce private medical information is deemed irrelevant. The seventh complaint is Slawomir Tamalsky versus T.O. Higgins and Company Limited, noting that this is the second case against T.O. Higgins and Company Limited. This complaint was submitted by Slawomir Tamalsky, arising from an incident that occurred on the 2nd of February 2021 at T.O. Higgins' Home Value Hardware store in Galway. The facts of this case are as follows. The complainant went into T.O. Higgins' hardware store on the 2nd of February 2020 and upon entering the store was asked by a member of staff to put on a mask, to which the complainant confirmed he was exempt. The complainant asked to speak to the manager of the store at this stage, and when the manager arrived, he told the complainant that he must produce a doctor's certificate to claim an exemption in their store. The complainant left and later returned that day with a copy of Statutory Instrument 296 of 2020, which sets out that a person is exempt from the requirement to wear a face covering where they have a reasonable excuse. The complainant advised the manager that wearing a face mask may cause a person to suffer from severe distress, and that severe distress is both a reasonable excuse under the regulation and a disability under the Equal Status Acts. At this stage, the complainant was again told that he could not enter the store without a mask or a doctor's exemption. At the hearing, the complainant explained that wearing a mask makes it difficult for him to breathe and that this can make him dizzy and sometimes leads to headaches and an accelerated heart rate. The adjudicator asked the complainant if he had any medical evidence to support these claims, and he said no, and this in effect led the adjudicator to finding against the complainant. In her decision, the adjudicator stated that where the claim to have a disability is disputed, medical evidence must be provided to support the claim. This should not be read as meaning that in all cases and in all circumstances, a complainant must provide medical evidence to, for example, avail of certain services or facilities where a disability is claimed. But once a complaint is made under the Equal Status Acts, that medical evidence must be available if the existence of a disability or whether that a disability qualifies within the meaning of the legislation is contested. The adjudicator found that the complainant has confirmed that he has no medical evidence to support his claims of disability. He has therefore no evidence to support a claim of discrimination based on a disability or that he should have been provided with a reasonable accommodation based on that disability. The takeaways from this case are as follows. 1. Even if you explain in detail the negative effects a face mask has on you, unless you have medical evidence to back up those claims, your case is unlikely to be successful. Now, let's think about this objectively. The complainant in this case stated that wearing a face mask causes him severe distress, and this leads to difficulty breathing, headaches, and dizziness. Exactly what medical evidence could he be expected to secure to prove this point? The best he could have done was repeat those symptoms to a doctor, ask that doctor to take a note of those symptoms, and then ask for that part of his medical file to be made available to the adjudicator. I ask you in all seriousness, how could symptoms relayed to a doctor by a complainant be considered better evidence than symptoms relayed to an adjudicator under oath? 2. With regard to the failure by the respondent to provide any type of reasonable accommodation to the complainant, the adjudicator found that, in general terms, if a person is seeking a reasonable accommodation for the purposes of a claim of discrimination, they would be expected to notify the other party and to provide that party with an opportunity to consider the specific request and to respond. The suggestion in this determination is that the onus is on the complainant to claim a reasonable accommodation as opposed to on the respondent to provide or offer one. The 8th complaint is Chloe Winters versus Hollins and Barrett Limited. This complaint is somewhat different to the others as it centres around victimisation of the complainant in her employment rather than a refusal of services. The facts of this case are as follows. The complainant worked in a Hollins and Barrett store that is located inside a Tesco store. The complainant had a medical exemption from wearing a face covering, which her employer had accepted and offered several reasonable accommodations in respect of. Although Hollins and Barrett's appeared to accept the claimant's exemption, the Tesco line manager inside which the Hollands and Barrett store was located did not appear to accept her exemption. The complainant raised a grievance with Hollands and Barrett regarding the treatment she was receiving from the Tesco line manager, and in this regard a grievance meeting was held on the 1st of February 2021. 1 hour after this hearing ended on the 1st of February 2021, as the complainant was doing her personal shopping in Tesco, she sneezed, and a customer made a complaint about her to the management. I want to stop here for a moment. I have to ask, what type of a society and people have we evolved into where a member of the public would see fit to make a complaint about a person because they sneezed? I expect that the complainant was not wearing a mask at the time, and I expect that she was wearing some kind of a uniform that identified the fact she worked for Hollands and Barrett. And I also expect that the person who made the complaint was an ignorant troublemaker who had no regard for any medical conditions that the complainant may have suffered from that would make it difficult or impossible for her to wear a face covering. Back to the case. The complainant was informed that a complaint had been made against her while the customer was still in the store, and the complainant thereafter went to speak to the customer to see why she had made a complaint about her, noting that this interaction lasted about 1 minute. You must remember at this stage that the complainant had likely suffered months of harassment from customers, staff members and employees of Tesco, such that she had raised a grievance with her employer, and this complaint about her sneezing was made 1 hour after the hearing of this grievance, so I can only imagine the state that the complainant was in at the time. So I question why anyone would deem it appropriate to tell her about this complaint while the customer was still in the store. The person who relayed this information to the complainant either did so recklessly, not considering all of the circumstances, or deliberately. Either way, given the discrimination that the complainant had likely suffered over a period of months, her employer should have been more understanding. But perhaps the instigation of this investigation was a convenient way to drive the complainant out of her job. After the customer made the complaint, Hollands and Barrett commenced an investigation into the complainant's conduct. The complainant argued that the investigation commenced by Hollands and Barrett was as a direct result of her raising a grievance against the Tesco line manager. Hollands and Barrett argued that these two issues were separate. In finding against the complainant, the adjudicator stated that the grievance made by the employee was not an operative cause of the disciplinary investigation commencing. The disciplinary process was commenced because of the alleged inappropriate conduct that occurred between the employee and a customer who had made a complaint. The complainant has not established facts of significance where I could reasonably conclude that victimization is within the range of inferences which can be drawn from the facts that she relies upon. In fact, the complainant accepts that she should not have approached the customer and engaged in discussion about why the customer complained about her. On the facts, the complainant has not been victimized. The takeaways from this case are as follows. 1. The complainant in this case accepted that she should not have approached the customer to ask her why she had made a complaint about her. I would normally tell people to admit that which you cannot deny, and in most cases you will be given credit for any such admission. However, in this case, the admission was used by the adjudicator to justify finding against the complainant. So I would say exercise extreme caution in admitting anything in these particular cases, as it would appear unlikely that you will be given any credit for any such admission. The 9th complaint is Martin Devlin versus Daly's Circle K and Spar Store. This complaint was submitted by Martin Devlin arising from an incident that occurred on the 5th of April 2021 at Daly's Circle K and Spar Store in Donegal. The details of this complaint are very limited, but what I glean is that the complainant attended at Daly's store and was asked to put on a face mask, to which he either refused or claimed an exemption. At this point, the person working in the store advised the complainant that he either had to wear a face mask or produce evidence of his exemption. A full hearing of this case did not take place, as the evening before the hearing the complainant contacted the WRC to say that he was unwell and would not be able to attend the hearing. The complainant contacted the WRC a second time on the morning of the hearing to confirm that he was sick and would not be able to attend the hearing. The complainant also engaged a solicitor to contact the WRC prior to the hearing to request an adjournment. The adjudicator found that the complaint was not well founded due to the complainant's failure to attend the hearing and the adjudicator's refusal to grant an adjournment. In my view, there is a bias in the tone of the adjudicator's determination, given the following wording. He was in touch with the WRC the following morning, but again failed to offer any supporting evidence beyond a bald assertion that he was sick. Noting that he was able to email the WRC and instruct a solicitor on that same morning in the hours before the hearing, this casts some doubt over his inability to attend in person online at the hearing, if only briefly for the purposes of applying for the postponement. On the facts set out above, there was insufficient grounds to grant a postponement. The takeaways from this case are as follows. 1. If you intend to seek an adjournment, do so in plenty of time, or alternatively, if the hearing is to be held remotely, you should write to the WRC in advance asking for an adjournment and also confirming that you intend to attend the hearing remotely solely for the purposes of seeking an adjournment. That concludes the cases. From the decisions published to date, the following are the best tips I can offer if you want to succeed with your case at the WRC. 1. If you have failed to initiate your complaint within 2 months of the incident occurring, the WRC has the ability to extend this period to 4 months if you can meet the test of explain and excuse. It should also be noted that the WRC has the ability to dispense with the notice period entirely where they deem it fair and reasonable to do so. So if you have filed your complaint late, make sure you have a good explanation for the delay. 2. If you are serving your complaint on the store by registered post and on post fail to deliver your complaint, there is an onus on you to try and serve the complaint again. In this regard, I would suggest that you serve the complaint by registered post, ordinary post and email if possible, and note on the ES1 form that it has been served using all 3 methods of service. 3. It is open to an adjudicator to dispense with the time period for notifications where they feel it is fair and reasonable to do so. However, given that the WRC has dismissed several cases because they were outside of time, it is highly unlikely that any adjudicator is going to extend the time period for service of face mask complaints. So try and ensure that your complaint is served within 2 months of the incident occurring. 4. Even if an adjudicator finds that you have been discriminated against because you were unable to wear a face covering, and even if the respondent destroys evidence in a clear attempt to obstruct justice, you are likely to only be awarded a small sum of money in compensation. 5. If you are unable to wear both a face covering and a face shield, and if you have a doctor's exemption, it should note that you cannot wear either. Otherwise, there is a good chance that the adjudicator might consider a face shield to be a reasonable accommodation, and if the store offer to provide you with a face shield and you object, you will likely lose your case. 6. While you do not have to provide medical evidence of your disability to the shop in question on the day that you were refused services, it is quite likely that if you fail to provide medical evidence at the WRC hearing, the adjudicator will not accept that you have a disability, and if you do not pass this first hurdle, the substance of your case will not be decided upon. 7. While you do not have to provide medical evidence of your disability to the shop in question on the day that you were refused service, given that the second part of this test requires that the shop is aware you have a disability before they can be found guilty of treating you less favourably because of your disability, it follows that your case is unlikely to be successful if you refuse to disclose to the shop the nature of your disability, such as severe distress or claustrophobia, etc. 8. Be aware that the adjudicator hearing your case will have their own views on COVID-19, and these views could easily prejudice their decision making. In this regard, I would be quite clear that any suggestion by the adjudicator in their decision that you refuse to wear a mask as opposed to being unable to wear a mask would give rise to an appearance of bias, and that the adjudicator should not allow any preconceived notions about why persons do not wear face coverings to shadow their decision making. 9. If the nature of your disability is severe distress, I would make clear to the adjudicator that you consider severe distress to be captured under Section E of the definition for disability under the Equal Status Acts, namely meaning a condition, disease or illness which affects a person's thought processes, perceptions of reality, emotions or judgments, or which results in disturbed behaviour. 10. If you intend to record an interaction where you are being refused service, you should inform the person you are recording while the recording is taking place that you are recording the interaction to produce as evidence at the WRC or court and do not intend to share it with any third party unconnected to such hearing. 11. If you intend to seek an adjournment of your hearing, do so in plenty of time, or alternatively, if the hearing is to be held remotely, you should write to the WRC in advance asking for an adjournment and also confirming that you intend to attend the hearing remotely solely for the purposes of seeking an adjournment. Finally, considering the determinations published to date, the most important takeaways are as follows. 1. At the adjudication hearing, you need to be able to say that you explained the nature of your disability to the store, such as, I cannot wear a face mask because I have claustrophobia, or it causes me severe distress and this makes me anxious, etc. It is clear from the decisions published to date that if you do not either produce a medical exemption to the shop at the time of the incident or explain to the shop why you are unable to wear a face covering, your case will fail. 2. While you do not need to produce evidence of your exemption to the store on the day in question, it is clear from the WRC decisions to date that the WRC will not take your word that you suffer from a disability. So to stand any chance of success, you need to produce some kind of proof from a medical practitioner to the WRC saying that you suffer from X, Y or Z when you try to wear a mask. While it would be better if this medical proof predated the date of the incident, if it is dated after the incident, this should not be considered fatal. And 3. From the 9 cases that I have summarised today, only 1 case was successful, even though at least 5 out of the 9 complainants had medical evidence that they had a reasonable excuse from the requirement to wear a face covering. What is abundantly clear from these cases is that every avenue will be exploited to ensure the substance of these cases are not considered, such as dismissing cases that are outside of the time limits for notifications, even though the adjudicator can extend this period or dispense with it altogether, to suggesting that a claimant was refused services not because of an inability to wear a face covering, but because they decided to record the interaction to use as evidence against the store. On a personal note, I appreciate that most of us are looking at this issue from a principled position, in that we do not want to disclose any private medical information to either a store or the WRC. And while I agree with this position, the purpose of this video is to explain to you what you have to do to win your case at the WRC. So when I am advising you to detail the nature of your disability to the store, or advising you to seek written medical proof of your disability to produce at the WRC, I don't necessarily agree that this is the right thing to do if privacy is your paramount concern. However, in this video I am relaying to you what the law is rather than what I would like the law to be, and what the WRC has decided rather than the outcomes I wish we had secured. So this video is not focused on what I would do or what I think, but what you must do if your primary goal is to be in the best position to win your case at the WRC. The only positive I can offer regarding the disclosure of your private medical information to the WRC is that you stand a better chance of winning your case if you follow the steps outlined in this video. And the knock-on effect from securing a high number of favourable judgments is that the next time our government decide to introduce totalitarian restrictions, including mandating the wearing of face coverings, shops will be less likely to ask for evidence of exemption for fear of losing their case at the WRC. Before closing, I wish to address the stores who harassed and intimidated those unable to wear face coverings over a period of 18 months. To you I say, the law only ever required you to inform customers of the regulations around face coverings in shops and encourage their compliance. The law never required nor permitted you to ask for evidence of exemption, but many of you were either too ignorant to read the law or too stupid to understand it. There was, of course, a third category of person who revelled in refusing services to persons who were unable to wear face coverings. Without apology and with no unease, I say that you people disgust me. You assisted in creating a two-tier society based on a person's private medical information. You assisted in creating an atmosphere of intimidation and harassment, and you facilitated the introduction and extension of totalitarian laws. Be under no doubt that we will never forget what you did, and I can assure you that a day will come where you have to answer for it. To those who stand on the side of freedom, you have my utmost respect for the intimidation, the harassment, and the prejudice that you suffered over the past 2 years, and for the way that you stood up to bullies. I hope you found this video informative. Now the decision is yours as to whether you wish to utilize the information in this video. Thanks for listening.